Hello, everyone. Welcome, welcome, welcome. Whether it's morning where you are, afternoon, or evening, we're glad you're here to be with us for our second When There's a Will, There's a Way Trust Wills and Estate Planning webinar. And we're so glad to have so many returning friends and so many new friends with us here at Food for the Poor in our community and beyond. Regardless of if this is the first time you're joining us at Food for the Poor and you've heard about us, we are glad you are here today. August is National Make a Will Month, in case you didn't know that. So we thought it would be an appropriate time to invite back one of our expert speakers to share some really good information with us. Our topic today is going to be how to keep your estate planning documents out of court. So we've got a lot of information to cover. It's all good stuff. So we're going to go ahead and jump right in. But at Food for the Poor, we start all things with prayer. So we've invited our Director of Missions and Travel, as well as she's in charge of our Angels of Hope program, which is a one-on-one child sponsorship program, Leanne Chong. So Leanne, would you be so kind as to start us off in prayer?
Thank you. Lord, we just thank you for this time today that we can come together to learn about financial and estate planning. All that we have belongs to you. So give us wisdom and discernment to help us make the right decisions, to be good stewards of our time, our talents, and our treasure. Show us how we can leave a legacy that will honor you and grow your kingdom. So please bless our special guests today. Give them the words to educate and inspire us. We just give you thanks and praise. And again, thank you for this time together. And all these things we pray in the mighty name of Jesus Christ. Amen.
Amen. Thank you so much, Leanne. We really appreciate that. So for those of you who've joined us before, you may be familiar with Dr. Adam Goldberg, but for those who are not, we have a very special speaker. I've known Adam for, I'd hate to say how many years, probably 20 plus years. He's been a longtime friend of the philanthropic, charitable sector. He has a practice in estates, trust planning, gosh, what else do you do? Probate, a number of different things. He's got clients all over the country, and he travels and lectures extensively on a lot of topics, including topics that are of interest to those of us who have philanthropic causes close to our heart. He is also an adjunct professor at 3 universities here in Florida, Nova Southeastern University, University of Miami Law School, which is my alma mater, go you, and Florida State University's College of Business. He has been named a Florida super lawyer in tax every year since 2017, and he's a Florida Fellow by the American College of Trust and Estate Counsel, among many other things. I've just kind of abbreviated his biography for you, but you get the idea. He's an expert. So Adam, we've got a lot to cover today. I'm going to let you kind of guide the way, but before we get started, we do have a poll. And this will help us, for you in the audience, discern what you're most interested in. So right now, what should be popping up on your screens, for those of you that are attending through the webinar in any event, I know we have folks on Facebook as well, you'll see something pop up, and it just popped up. What are the main factors influencing your decision to engage in estate planning? And we have a couple of different topics. I'll run through them while you are answering, and then we'll close out the poll. Is it a concern for ensuring a smooth transfer of assets? Beneficiaries, desire to minimize taxes and maximize the value of the estate you wish to pass on, the need to designate guardians for minor children and dependents, complex family dynamics that require just special considerations, or wishes to support charitable causes as part of the estate plan. We understand there may be more than one, but pick the one that's kind of most relevant to you, and we'll go ahead and give you just about 5 more seconds to make your selection. And we can go ahead and close out the poll. Thank you very much for our folks in the office. So it looks like right up there, you should pop and see the number one at 57% is concern for ensuring a smooth transition of assets to your beneficiaries.
Perfect for today's topic.
Right on point. Okay, great. And we're going to try and cover some of the other topics as well. But now we have a guiding point. So without further ado, Dr. Adam Goldberg, you want to take us through some of the considerations for us?
Let me thank you again for inviting me back. I was talking to some of the people here in the hallway, and they reminded me of a story I told last time, so I'm going to start with a story again this time. So a number of years ago, we had a woman pass away in West Broward. She had 3 kids, and she had no will. In theory, that should make things easy because everything's going to go a third to her 3 kids. She was divorced, and she had 3 adult children, and the state of Florida fills in the details for her. The problem was is she didn't divide up her tangible personal property, and her 3 kids disliked each other greatly, and I'm being polite. So each kid lawyered up, and the client's position was, I would rather the money go to you than anything go to my brother or sister. We represented one of the daughters in this case. And it got to be so difficult to distribute the tangible personal property that we eventually had to hire an appraiser to come in and appraise everything in the house. We were going to give the 3 kids monopoly-style money to bid on things to try and get them to come to some type of an agreement on the distribution of the tangible personal property. It's not like this was a big house or there was a lot of expensive things. Well, we had the appraiser come in. It took 2 days for the appraiser to put prices on everything. And then one of the attorneys came in to take a peek and said, you didn't appraise everything. And I said, what do you mean? Well, like the plates for the electricity. You didn't appraise, every individual fork. So then the appraiser spent 2 more days appraising everything. We finally had the 3 beneficiaries and their attorneys come to the house with a formal, traditional person to run the auction, and they had play money. And so the 2 daughters, which was one of my clients, were bidding on lots of things. The first day went through, we got through about 60% of the house, and the son had bid on nothing. The second day comes, we finally get to the kitchen, and the person heading the auction holds up a lasagna pan. Crusty, old, yucky, rusty. I'd pay you not to make me take it. But all of a sudden, the son stands up, says, I bid all my money on the lasagna pan, takes the lasagna pan, and walks out the door. Obviously being somewhat stunned, but we completed the auction with the 2 sisters finishing up. I can't imagine how much money was spent on auctioneer, valuation, attorneys, and all of the process going into this. But what we later found out, because I had to ask, was what in the world just happened with the son? And he said, my mom would make lasagna every Friday night for dinner, and that's the only time I can ever remember this family being happy. And so lasagna pan meant everything to him, and that's all he cared about. So he sat through a day and a quarter of auction with the sisters that he couldn't stand just to make sure he got the lasagna pan. So there's an example where a smooth transfer was difficult, not because of lack of planning, because the state of Florida filled it in, but just not going through tangible personal property. And people get very connected to that. I only have 1 antique car. I can't cut it in 3 pieces and give 3 pieces to each of my kids. I only have 1 wedding ring. I can't cut it in half and give half to each of my daughters, potentially. So sometimes we mess up on little things. And it's funny because Robin Williams' estate was an example of where the money wasn't the issue. They were fighting about pajamas, his awards, and his bicycles. He had a bicycle collection. So sometimes we see the people fighting about little things in probate litigation. And sometimes the little things make a big difference. So.
Indeed. Oh my gosh. Okay, so hopefully you're going to give us some tips on how we can ensure that smooth transition.
Yeah. So let's talk about the different types of probate litigation that are out there. So some of them start very early. One of them is called a caveat. And for those of you that are listening outside the state of Florida, I want to let you know that each state has its own process for this. So what's true in Florida is not necessarily true in California. Texas, Florida, and New Jersey are somewhat similar. California is a little bit easier on these things. So is a place like Georgia. New York is one of the most difficult places for process, just to give you an idea. But we're going to talk mostly about Florida here. So in Florida, one of the easiest ways to question a procedure that's going on about somebody's will or estate is called a caveat. A caveat is just a way to tell the court, hey, I may or may not have an interest in here, but I want to receive notice of what's going on. The court will not stop anything because of that, but it allows you to be kept aware of what's going on. Another way of saying this would be a request for notice in some jurisdictions, but Florida, it's called a caveat. There is a small filing fee for this, and it doesn't mean you get open time in the court. It just means that anything that comes along, we have to serve you a copy of. So if you think you've been disinherited, or you might have an interest, or you're a creditor, maybe the dead person owed you money, those would all be little ways to get in. Another type of probate litigation is competing petitions for appointment. We recently saw this with a gentleman in Haiti. Unfortunately, the gentleman had passed away in Haiti during one of the earthquakes. And the problem is he had no documentation. And again, another family that didn't get along very well. So he had a number of brothers and sisters, and every single brother or sister filed a petition with the court wanting to appoint them as personal representative. In Florida, that's what we call it. If you're in a jurisdiction, it might be executor or executrix in New York and some other jurisdictions. So that's a case where nothing's going to happen because we can't even get an agreement on who's going to be in charge of the estate. And that's usually because there was no will. Some of you might remember that Aretha Franklin and Prince had questions with old wills versus new wills or no will, and who is the right person to serve. So that's an issue as well. The one we see more often is the validity of existing documents. This is somebody arguing that the will or the trust or the beneficiary designation is not appropriate. A lot of these are what you would think. Well, grandma was off her rocker. So when grandma did that will at the age of 89, she had already been diagnosed for Alzheimer's for 7 years. So the fact that she disinherited me, she didn't have the proper mindset to do that. So that's questioning capacity. That is very, very common when people leave things unequally or people disinherit. And remember, for most every state other than Georgia, if you're married and you don't have a prenup or postnup, you are required to leave something for your spouse. Okay? So we'll talk about that more in a little while. Then we have fraud, duress, and mistake. So if somebody was so impressed with the presentation I gave today, when I walked outside of the recording studio and they asked me to sign my autograph, and being the jerk I was, I signed the autograph. Maybe I signed a will and somebody secretly had me sign a will. So that would be an example of a fraud. Somebody had me sign a will that I didn't realize I was signing a will. Duress would be somebody was pressuring me into signing. So we make the argument that grandma really didn't want to disinherit me, but my brother who lives with her and forced her to do this against her true wishes. An example also that would be undue influence. The person is so under the capture of somebody else that they can do it. Let me give you a quick example of that. I represented a charity a number of years ago. The person had left the charity in their will for 45 years. 5 months before they died, the person did a new will, leaving nothing to the charity. What we came to find out was that person had fallen, broken their hip. They had a full-time caregiver. 2 months into the job, the caregiver brought that person to their own divorce attorney, had them do a new will, leaving everything to the caregiver, and then the person died 3 months later. The caregiver was one of the witnesses on the will, and the caregiver's son was the other witness on the will. I think you're getting my point here.
I do.
And the point of the matter is, you can probably make a very strong argument there that that caregiver unduly influenced that decedent to do a new will appointing her as a beneficiary as opposed to the charity that was there for 45 years. So those are the types of things that we see there. Sometimes we have statutory grounds. So in order to do a valid will in Florida, it has to be signed in front of 2 witnesses. The notary is technically optional, but we do encourage a notary. So the only test for the witnesses is we have something called a conscious presence test. That means the witnesses actually have to see the person sign their will, ideally by being in the same room or at least having that person come and saying, yes, I signed this an hour ago, but that is my signature. And so all the parties are supposed to watch the signature taking place. If that doesn't happen properly, then you can argue the will was not done properly. Maybe there was only one witness. Maybe one person witnessed twice. The witnesses have to be over the age of 18. Maybe the witness was only 16. Maybe the person that created the will wasn't 18 years old. Maybe they didn't sign the document at the end of the document. So these are places where the Florida statutes would save you, or in terms of your challenge, because the document is ineffective and hence illegal just on its face because it wasn't signed in the proper fashion. One thing for my Florida people out there is in Florida, we do not have a disinterested witness rule. What does that mean? That means that your spouse your kids, if they're over the age of 18, could actually serve as witnesses to your will. I wouldn't call that a best practice, but it doesn't mean the will is ineffective on its face, as it would in many other jurisdictions. A lot of times we get arguments regarding whether or not a document was revoked. We can't find Grandpa's original will, but I have a copy here, and the copy of the will leaves everything to me and nothing to my sister. My sister's going to make the argument, well, he must have ripped up the original, so the fact that you have a copy doesn't mean that that is what his wishes were. So we have issues regarding the revocation of a document. Sometimes, and these are going to be less, we see these less often, we have a document that's against public policy. In Florida, you cannot leave something to someone based on whether or not they are married or divorced. So if I don't like my sister-in-law, and I say in my will I leave 50% to my brother provided he has divorced that wife of his, that's not going to work. If I say in the will I want to give something to my granddaughter, provided she is still a member of the Protestant church or whatever, fill in your favorite, then again, this is something that's against public policy and it would make the document no good on its face. Another interesting point is an terrorem clause. A lot of these are Latin. I'm going to explain what that is. But an terrorem clause is a clause in a will or a trust that says, if anybody challenges this will or trust, they get nothing. That's a great clause, and it works in 49 states.
49.
But the missing exception is Florida.
How about that?
How about that? So it used to be Indiana and Florida, but Indiana just changed their rules. So an in terrorem clause is invalid in Florida. That means you can't put in a clause that says, I leave my things, 40% to this child and 60% to this child. And then put in a clause that says if 40% child challenges this document, they get nothing. That's not going to work in Florida.
But it might work in other.
It works in every other jurisdiction.
It's just provided Florida, it's written well. Right?
Exactly correct. So Florida is the one place that is not. We have another. Again, we're getting to these extreme examples. One is a rule against perpetuities. If we have any lawyers out there, you remember learning about this in law school. The rule against perpetuities was originally created so that you couldn't tie assets up for extended periods of time. You didn't want to be able to lock things in place for too long. Some states have done away with it. South Dakota, Alaska, Delaware, except for land. So you can now create trusts that in theory go on forever. In Florida, the rule used to be 360 years. Basically, if the trust lasts more than 360 years, then it's invalid. Florida just changed that to 1,000 years because it was losing trust and estate business to other states. So now you're limited to 1,000 years. What that translates to for purposes of today's discussion is if you create a trust that's going to last more than 1,000 years, it's invalid on its face. So it'd easily be something that you can challenge. Then we get into the weeds. This is going to be will construction. And what I mean by that is we're going to be analyzing particular clauses. Was there just a bad handwriting and that 40% looks like a 90%? Or the percentages don't add up to 100%. We see that more often than I'd like to admit. So what do you do when the will leaves 80% and then doesn't say what to do with the other 20%? Or what do you do when the will leaves 122% out of 100 instead of 100%? We also see some wills where they look weird. I had a will a number of years ago before I was starting this firm where there were 6 pages that were letter size and 1 page that was legal size. That in and of itself caused me some problems. And of course, what else was it? The type style was different. We go back to the days where you had mimeograph paper, but nowadays with computers, it's very easy to make changes. So sometimes we see documents that somebody attempted to modify them and they didn't do a very good job of it. And so whether or not we have a valid document is open for discussion. The other issue I want you to realize in almost all the jurisdictions out there, including outside the state of Florida, is these cases tend to move very slowly. It takes a lot of time to gather information on a decedent's mental health. It takes a lot of time to try and determine what was going on in their life at the time. And it also takes a lot of time because the probate courts are not the courts that get a lot of the judges. In other words, in Broward, we've only got 3. In Dade County, we only have 4. So it's not unheard of for a probate litigation case to kind of go 2 to 4 years. Most of these cases are done on a full contingency fee basis, which means the attorney who represents the party that feels wronged is going to get a percentage of the collection. So that might make it difficult for settlement purposes, although it is nice because the party that's complaining might not have to put any money out of pocket. Of course, some things are also done on an hourly basis. Another issue what we see in probate litigation is whether or not somebody is really related to you. Prince is the best example for my music lovers out there. Did he have any children? Was he ever married? Were there real sisters, real brothers, half sisters, half brothers? Florida, and so is Minnesota, are jurisdictions where half-bloods still count for only half. So if you die with a full-blood brother and sister and a half-blood brother and sister, the brother and sister that are half-bloods only get half as much as the full-blood brothers or sisters. So as you can see, Florida's a little backwards in some things in the way that they do things. But these are interesting rules, and it affects the ability to do it. What happens more often than not is somebody dies and we don't know who to give the money to. We have one of these in our office right now. And so we have to hire companies to do this. The Mormon Church in Utah is a great place for doing this type of family background. For those of you that are listening, I said this last time I was here, I'll say it again. Go to fltreasurehunt.org. There's one for every state, but the one for Florida is fltreasurehunt.org. Type in your name, your spouse's name, any of your adult kids' names, any relatives you know that may have lived in the state, and see if there's any money sitting there for you. Those are normally cases where we didn't know who to give the money to. In Florida, it sits in that for 10 years, and then the state of Florida gets to keep it.
Interesting.
So
you might as well check.
Yeah, no, we do that in my classroom, and every few years we get a student who finds something.
Interesting.
And it can be a lot. We found $75,000 for somebody who had been dead for 12 years somewhat recently. So those are always interesting. We also see cases of whether or not somebody was really married. We see this a lot, unfortunately, with some of the Caribbean countries where they were married there. Does that mean they're married here? And usually that's going to be yes, although it depends a little bit on what the process was. Then we see whether or not was somebody really divorced or not. We've had a couple of occasions over the years where the kids thought mom and dad were married, but they were secretly divorced and never told anybody. And of course the opposite. Mom and dad always passed themselves as divorced, but they never got divorced. So that throws a monkey wrench into this system as well. So these make smooth transfers, which was our winner in the poll, very difficult to accommodate because we don't have all the facts or things have been done improperly. Then we have just your out of the blue story. You make the argument the day that the will was signed was Super Bowl Sunday, and Uncle Joe had a history on Super Bowl Sunday of having a big party with lots of alcohol, and he was drunk by noon. So, if he signed his will that day, there's a good chance he was drunk and it wasn't an effective will. So you do see, these are done on a fact basis, in other words, an issue by issue basis, and I can come up with lots of different stories like that, but that's just something to think about. Then sometimes we have difficult beneficiaries. We had a gentleman who did not do a will, despite the fact my office begged him to. He had 2 sons, so when he died, it was 50-50 to his 2 sons, which in theory should be simple, except for the fact that one of his sons was a convicted felon sitting in a state prison in Idaho. Let me tell you something. We don't want to be giving hundreds of thousands of dollars to somebody who's probably going to spend the rest of their life in jail. It's a danger not only to them, but also to the prison population as well. And so we learned how to go through the warden and how to put money in his commissary account and make sure that, there wasn't anybody in the prison that was going to know that this person was worth hundreds of thousands of dollars. So those are things to think about. When we're looking at the beneficiary level, we also have to keep in mind sometimes beneficiaries are in government assistance programs. Can they inherit anything? I want to leave everything to my 4 kids, but I have 1 kid who's on government assistance. And
that is a question we've received a lot.
Yeah.
How does it impact, Medicare, Medicaid?
Absolutely. And that can cause somebody to lose their benefits. And as much as I want the money, every month. It's the access to the medical care that's the most important feature. You have somebody that gets kicked off Medicaid because they have too much assets that they've got to spend. It can take months or years to get them back on that program. So that is a big one, and we do see that sometimes, and that's lack of planning, but it also can mean a bad transfer. You know, somebody has a special needs child or grandchild, and we've got to deal with what are we going to do with these assets. One of the things you and I were talking about today was funky assets. We had a client who had a reptile farm. That's not something that everybody wants in life.
Right.
I don't know what I would do with a reptile farm, okay, if you left that to me. So you know, we talk about jewelry, stamps, you know, unique assets. You know, my uncle collected, you know, a bunch of antique cars, but they're all in bad shape, and he's left them to me. Well, that's great. What am I going to do? Where am I going to keep these cars? You know, maybe I'm not a car lover. And so those are all things that we think about. So those are all the types of things that we tend to see. So I'll give you one more funky story. We had a woman who had a will. Everything was planned perfectly. She left everything to her daughter who lived in Minnesota, and daughter was in charge of everything. Okay? The will was 20 years old. Unfortunately, between the time that mom did the will and mom passed, her daughter had a serious illness and had grown to 500 pounds. She could not leave the house. So what do we do in that case? All the documents are perfect, but I can't bring my personal representative down here to do anything. So that's a case where, again, should have been a smooth transfer, facts changed, and we had to do things a little differently.
I believe that's why we talk about, or you recommend, you know, with some regularity reviewing your current estate plan. What is your recommendation?
Oh,
for
you
that?
walked me down the path. Thank you so much.
You're welcome.
So my encouragement is once every 3 years. Okay, just pull the document out. Most of you have attorneys that hopefully would, you know, be happy to do a very reduced price or no charge to review your document. You may be able to review it yourself and just say, you know, this is still represents what my wishes are. There's a few exceptions. Number one, you won the lottery, you inherited a whole bunch of money. Those would be reasons to see somebody much more quickly. Number two, you got sued or you're facing a major lawsuit that you're concerned about liability issues. That'd be another reason. Number three, you have new family members, but I mean that a little differently. I'm not overly concerned about your natural born grandchildren. But if your son just married a woman who already had a child from a different relationship, that's a step grandchild. Would you want to treat the step grandchild the same way you treat your own grandchildren? That's something to factor in. So those are all things that, you know, affect us after the fact, and it would be a reason for us to look at the documents. Obviously, financial situations change, divorces, changes in the law. We're expecting a big change in the estate tax law at the end of 2025. So, but there's 2 elections between now and then, so we'll see how that changes things. So right now, the magic number for the estate tax is $12,920,000 per person. I wish all of you that problem, okay? And my married couples out there, remember it's double. So you both get it. So only less than 1/10 of 1% of the U.S. population is affected by that right now. But should you win one of those big Powerballs or something like that,
Or if you have appreciated property, I would say that would be the other
absolutely,
thing.
it would all be things to do. Or you're shutting down a business. You know, I've been in this family business for 30 years. We're getting ready to cash out. That'd be a reason to revisit all of our documents. So, but generally every 3 years is a good indicator. If you're in a state like North Carolina or other states where you can deposit your will with the court in advance, Florida is not one of those states, then you'd want to make sure that the one that's deposited with the court is still the most recent. And normally called a document repository. But in Florida, you can't particularly do that. So those tend to be what we see in probate litigation as it relates to outside forces or actions or inactions. Let's talk a little about the rights of the surviving family. So rights of the surviving family are things that are difficult to get around, and there are protections. Every state has some of these. In Florida, we have something called the elective share, for example. So if I was on the outs with my wife but not divorced, and I did a new will leaving nothing to my wife and I died the next day, the state of Florida protects her because she is my spouse. And what the elective share means is that I can't give my spouse less than 30% of my estate. That means that she can come to court and say, we never got divorced, and despite the fact that we were living apart for the last 10 years and talked about divorce, I want my 30%. and that's elective share. And unless I had a prenuptial agreement or a postnuptial agreement, that doesn't change. And you could have a whole conversation on family law matters, but that doesn't change, and she would be entitled to her 30%, no matter what the will or the trust says. We've had happen where there's been arguments on whether or not a prenup or postnup was ripped up, just like I said the will earlier. So we had one where, because we couldn't prove that the prenup wasn't ripped up, even though the will said, I leave my spouse nothing because we have a prenup, because they couldn't find the original prenup, the wife was able to claim the 30% elective share, much to the chagrin of the husband's son from the prior marriage. So again, not a smooth transfer. We have something called family allowance and exempt property. Family allowance is the ability to let the family have some sum of money while the administration is processing. In Florida, that amount is $18,000. So not a lot, hasn't been indexed for inflation. I wish it would be, but it allows the family to at least have something to live on while we go through a probate procedure. And you have to ask for it. It's readily available and very difficult to challenge, but you have to make the ask. Exempt property are assets that are not subject to creditor claims in a probate. So these include college savings plans, life insurance for teachers that died on the job, but the more common ones is $10,000 worth of tangible personal property and any cars that are regularly driven. If you have a car with an antique tag on it, that's going to be hard to make that argument, but as long as you can show the car is regularly driven, it's not subject to creditor claims. So again, these are things that the family can claim or certain people can claim despite whatever the will or the trust says. For my clients that are in Florida, or for my people listening here that are in Florida, and to a lesser extent in Texas and New Jersey, we have homestead. You're familiar with homestead.
I am.
Okay. So my Florida people, you will know that homestead can be a very good thing. There is a reason why a lot of people with financial troubles, we won't pick out any names, but a famous former football player and Bernie's wife moved to Florida. Bernie Madoff's wife moved to Florida. And the concern, of course, is that you want to make sure that creditors can't touch your primary residence. And that's what homestead does in Florida, like no other state. Florida's a good state to live if you owe people money, but that's asset protection. That'll be a subject for another
A different
day.
topic, yeah.
So, but homestead overrules. So again, if I have a will and it says I leave nothing to my spouse, but if I was married, my spouse has a homestead right to my house. I cannot disinherit him or her from the house without doing a prenup or a postnup or them signing off on a deed. When I say them, the spouse that's being taken away the interest from. Homestead also protects children under the age of 18. You're limited on what you can do. So if I die having children under the age of 18, I can't leave my homestead to Miami Metro Zoo, or I can't leave it to Food for the Poor. I have to take care of my children under the age of 18. And that brings up arguments on whether or not somebody was really your child. You know, did I adopt this person? You know, who's on the birth certificate as the father or the mother? More usually on the father side of things. So those are working two sides, both things from probate litigation perspective, but also rights of the family. In Florida, if you are legally adopted, you are treated the same as a natural born child, but you lose the right to inherit from your birth parents. Rules in different states have different things, but that's the rule in Florida. We talked about paternity issues and we talked about half-bloods. Again, those are things to think about. We have something called a killer forfeiture statute. I have taught that subject for 25 years, and only recently do I finally have a case that this involves in. We had a father and daughter who got into an argument, and the daughter ended up killing her father. And what killer forfeiture tells us is that if you are involved in the death of the person, you cannot inherit from that person. But it's a lesser standard than a criminal standard. So in this particular case, it's basically the preponderance of the evidence would be the standard. So you could be not convicted in a criminal court of murder, but you could be convicted in a civil court, and then you cannot inherit. So this father that died, he had 2 kids. He had no will, so in theory, half should go to the one kid and half should go to the kid that was involved in his murder. And this killer forfeiture statute makes it so that she would not be able to inherit from her dad if it's proved in a criminal or a civil case. A few other little things to keep in mind. We have something called pretermitted child or pretermitted spouse. These are cases where you have a will that was signed before the child was born, or you have a will that was signed before the marriage. The state of Florida and almost every state other than Georgia assumes that you didn't mean to disinherit that child or that spouse. You just never got around to doing your new document, so they have protected. And a pretermitted child or a pretermitted spouse means you will inherit even though the document didn't ignore you or acknowledge you at all. And what that means for a spouse is they would inherit 50% of the estate, again, assuming there was no prenuptial agreement or postnuptial agreement. And for a pretermitted child, they would inherit whatever the other children would have inherited, or if they're the only child. A few other little things. We have something called a simultaneous death law in Florida. This is to protect so that your wishes can get carried out. So we're going to talk about a horrible thing, and I don't think my wife is listening today, so I'll use her and me as the example. If we were crossing the railroad tracks and a train hit the car, and I died first because the train hit my door, my will said leave everything to my wife. My wife died a second later, and then everything would go through my wife's will. If we could argue that I somehow survived my wife, by a second, then it would go under my will. My will might leave everything to my nieces and nephews, and maybe my wife's will leaves everything to her nieces and nephews. So they're going to fight about who died first, because we want to make sure that, because the train hit the driver's side of the car first, Uncle Adam must have died first, so everything went to Aunt Elena, and everything goes through Aunt Elena's will, not Uncle Adam's will. So if the wills are different, that makes a big difference, and that's called the simultaneous death law. If there's anybody listening in North Carolina, you've got two funky versions of that. And by funky, I don't mean bad, just very different than some other places. If you die from the same accident, they're going to cut everything in half. It's presumed that you died at the same time, even if somebody survived for 72 days, but it was from the same car accident. That would be an example of the family wanting to prove, well, yes, the car accident caused the injury, but they actually died of something else, because we don't want to necessarily use the simultaneous death law, or a 72-hour rule. Now, in almost every state, you can set these rules up to be whatever you want. But most of the time, we don't see that. We don't see too many wills that talk about what happens if I die at the same time as a beneficiary. The example we'll give for most of you out there, you love your son, you tolerate your daughter-in-law, or vice versa. You love your daughter and you tolerate your son-in-law. We'll use that example here. So you leave everything to your daughter. Your daughter dies the next day. What does that mean? It means everything goes to your son-in-law if that's what her will says. So these are survivorship clauses. You can say, I leave everything to these people provided they survive me by 30 days or whatever it is. I don't like to go more than 30 days because it slows down the process, but we've seen people use 90 or even 180 days. But that all deals with simultaneous death. We also have something called the anti-lapse law. And I'm going to use a car that I used to own, which was a 40th anniversary Corvette, which I use as an example all the time. My students always know I like to talk about Corvettes. So I sold my Corvette a number of years ago because I wanted to help buy a house with my new wife at the time. So I don't own it anymore. But if I still did and my will said I give the Corvette to my brother Jamie and then I die, Jamie doesn't get the sales proceeds. The car has disappeared and therefore he doesn't get anything to replace it. The same would be true if I said I give my brother Hadley 100 shares of Apple stock. The day before I die, I sold it, so it no longer exists. It disappeared, and my brother Hadley doesn't get the money in lieu of the stock. And that's a Florida rule. That's an anti-lapse statute. It also, under this same similar rules, we make sure that if I leave things to my brother and he dies, do I want it to go to his kids or do I want it to go someplace else? And if the document is silent, we sometimes see people fight about those things. So when you have small families and you have a tragedy where multiple people pass away at the same time, we a lot of times see problems like that. Where are things going and who died first? And does it matter who died first? And what were they a resident of? They were moving to Florida, but North Carolina is better for my argument. So I'm going to argue they were still a North Carolina resident because the plane never made it to Florida. Horrible stories like that. So these are, and we'll talk about creditor claims in just a second, but what we've just talked about, automatic rights of the family by statute, and then just general, doing a will incorrectly or mistakenly, or a person not having capacity at the time, or being unduly influenced by others, those tend to be the most common forms of litigation that we see with wills and trusts. But don't lock it into just wills and trusts. People also have to designate a beneficiary on a 401k or an IRA, which, as a satellite, would be a great asset for your planned giving and charitable giving for an organization like Food for the Poor. Got to throw that in.
Thank you.
Okay. But when did somebody list those beneficiary designations? We don't have the luxury of having witnesses and a notary on those things, but those are things that we think about as well. An example, again, this is a made-up example, but if I was expecting to inherit everything from my mom, but 2 weeks before she died, my mom's brother came to the house and said, why don't you put me as a beneficiary on all your accounts and I'll split it up among your kids. Well, I have a case against my uncle now saying, Uncle, you unduly influenced my mom because she was going to leave everything to her 3 boys, but you unduly influenced her into making this change. So that's called intentional interference with a devise or with a bequest. That's a tortious type of probate litigation. And why does that matter? It means I can get in front of a jury for that type of thing. Juries tend to be a little bit more lenient than judges do. Mostly in probate litigation, it's judge only, at least in Florida and a lot of other jurisdictions. But if you can bring it into some other forum and you can get in front of a jury, tends to be better for the person bringing the case. Look at all these horrible things my uncle did to my mom before she died to get her to do this, as opposed to letting some judge make the decision. Sometimes a jury of your peers might be a little bit more understanding of these things. Now, there's different versions of everything we just said. There's homestead litigation cases that may factor in, and sometimes these are worked in as part of a wrongful death or a medical malpractice. We talk about some yucky things, not a very formal word there, but so we're talking about these as part of mom or dad didn't have much, but they died in the operating room table. Did the hospital, did the plastics, did the surgeon do something wrong? And who would be the beneficiaries thereof? So it can be stacked on. We might be fighting about whether or not somebody owes us some money, but we're also fighting about who's going to get those funds. So that happens as well. From a creditor's perspective, so if somebody owes you money, you have certain rights as well. In Florida, for example, there are 8 classes of creditor claims, and everybody in the class gets paid before we go to the next class. So let me give you an example. Class 1, and this is an example where you want to be Class 1. Class 8 is the bad place to be. Class 1 is the good place to be. So that means before any beneficiary gets money, we get up to $6,000 to reimburse whoever paid the funeral bill. The personal representative's fee, if you're in another state, fill that in with executor or executrix, and the attorney's fee, and then any costs of administration. So those are all going to get paid before we get to the next class of creditors. As you would imagine, credit card claims would be a Class 8 creditor. They're unsecured. If you have a TV that you're renting, they're higher class because they can always come and take the TV. Your mortgage company is, believe it or not, they can take the house, but any money that's owed on top of the house is a Class 8 creditor claim, which is not where you want to be. Some of the other ones, if you didn't pay child support, shame on you, that would be a higher class. Other higher classes would be Medicaid or Medicare, if those things were being paid. Other things would be the cost of running a business during administration, the elective share. Some of these things they're different claims of creditors in terms of where you sit. And one of the reasons credit card interest rates are so high is because in estates, a lot of times the credit card companies get very little or nothing on their money. They're unsecured, and we have to wait and see if there's going to be any money left to pay the Class 8 creditors. So now, again, every state has different places to go, so keep that in mind. And somebody might be a multi-class creditor. So if I paid $10,000 for the funeral bill, the first $6,000 was a Class 1 claim, but the other $4,000 might not be. It would only be a Class 8 claim. So I don't want to spend too much time on that, but that's another way to get involved in probate litigation, because then we get to fight about, well, what are you really owed? And can we settle for something less? Or do you get interest on that money while we're waiting to get paid? Let's get into a little bit more now about what actually happens in a probate litigation.
I think that would be interesting for people to understand. So
Yeah.
so you've passed away. What happens next?
Yeah. So you've passed away, and let's assume that somebody wants to challenge your will or the process. So the first thing is there has to be a probate going on. One of the reasons why a lot of people like to do trusts now or list beneficiaries on everything so there is no probate is so that there is no forum readily available for somebody to challenge something. So you're putting up a barrier to that person to challenge. So we'll use my family. My family consists of my mom and her 3 boys. I'm the oldest of the 3. Let's assume that my mom had disinherited me and left everything to my 2 brothers 50-50. Maybe I knew about it, maybe I'm okay with it, but let's assume that I was not. So the first thing I want to see is, copy of the will. Was there a probate? And if there's not a probate, I want to start one quickly because I'd like to get everything, I'd like to get some litigation involved before my brothers take the money and leave the country or whatever they're going to do with it, knowing that what their brother does for a living, chances are he's coming after them. So the point is that you want to get that process started as quickly as possible and try and move it along. In Florida, you have a 90-day creditor period where basically that's the time for somebody to come out of the woodwork and complain. In New York, there's a version that's 2 years. That's why we say New York is a difficult place to do these things. In California, you might be able to do this without anything of any kind. So disposition by affidavit. So every state's jurisdiction is going to be slightly different. But normally what we're talking about is, are we challenging a document, or are we challenging the asset itself, or are we challenging who the beneficiary is? Because all of those are different. So when we're challenging the document, we want to bring in expert witnesses to say why this document is invalid. If we're challenging the mental capacity of a person that created the document, we want to bring in doctors and others that have interacted, social workers, with the person while they were alive to argue why they didn't have the capacity, or at the time they signed the document, they didn't have capacity. If we're challenging the process, then we're normally claiming we have a certain protection, like a homestead protection or an elective share protection, and it doesn't matter what the will or the trust says, I'm entitled to this and I want you to give it to me. Okay? And there's all the different things that fall in. But from a probate litigation standpoint, somebody has to open the probate. Then you want to make sure you bring the action in a timely fashion, normally during those 90 days, because after that it makes it more difficult to do so. And then you have discovery. You have something that's now a contested issue, and discovery could last months, it could last years on occasion. Again, look at how long it took for Prince's estate to kind of get resolved, and we're watching Aretha Franklin now in Georgia with a similar situation. So these things can take a long time to run themselves through. In addition, remember that one of the interesting facets about this is when you're fighting about this, the person that's in charge is fighting with house money. What do I mean by that? They get to use the assets of the estate to defend against the action being brought by the other. So if I was, I'll change my fact pattern. If I got, my brothers were each left 40% and I was only left 20% and I'm challenging this and my other brother was in charge, I'm eating away. I have to pay my own legal fees, but I'm also, some of the money, that 20% that I was going to get, is being used to defend against me. So sometimes you're paying both sides of the equation from a litigation standpoint. So that's always interesting. Most of these cases settle. I would say the last time I saw the chief probate judge, he said about 97% in Broward County of probate litigation cases tend to settle, and that's really what the court wants. The court doesn't like to make ultimate decisions if it doesn't have to, and it's better for both parties to walk away unhappy, is kind of in the eyes of the court. Sometimes we're fighting about the amount of money that people are being paid. We've had people complain those lawyer fees look way too high, or the trustee fee or the personal representative fee is way too high. In Florida, we have the luxury of having a statutory set reasonable fee. If you take the reasonable fee and somebody wants to complain about it, the burden is on them. If you take more than the reasonable fee, now the burden is on you to show why that fee is reasonable and why you should take that, why you should be able to get that fee. So that's compensation disputes. And just to give you some quick examples, if you had an estate of $100,000 to $1 million, A reasonable fee for a personal representative would be 3%.
Now, when you're talking these numbers and you have real estate involved, because a lot of people own homes, that's their
Yep.
largest, does that count towards this
If
amount?
it's part of the probate estate, it counts. So the question is was it owned in the decedent's sole name? So husband and wife own a piece of property. If husband dies, we don't have to do a probate. It's going to the wife. Or my wife died years ago, but I have the property and I've left it life estate for me, remainder interest to my 2 nieces. There's no probate. It goes to my 2 nieces. But if it's just in my name when I die, it's subject to probate. And now it would be fair game for any probate litigation that's going on.
Thank you.
The problem with that, of course, is that we don't have the equity out of the house, so we're fighting with very little cash sometimes. So, and that does happen a lot. But yes, it counts for purpose of this. I gave you the 3% on 100,000 to $1 million. I'll give you some other numbers. If you have an estate that's 5 million to 10 million, that fee drops down to 1.5%. If you have a really small estate like under 70,000, what's considered a reasonable fee is $2,250. So, just something interesting to note. So, what do we learn from all this probate litigation?
Yeah, let's boil this down to give some folks some
Yes.
practical
All right.
tips, because we want the smooth transition, right?
That's right. We
the
want
goal.
the smooth transition.
Okay.
So, what do? Number one, we review our documents on a regular basis, about every 3 years. We review how our assets are titled every so often, again, every 3 years or so. We review our beneficiary designations on life insurance, on accidental death policies, 401k, 403b, IRA, SEP, Roth IRA, Roth 401k, on all the retirement assets.
LMNOP. Yeah.
We walk through the house and say, is there anything on the wall or anything that people are going to fight over? I have 3 daughters, but only 1 wedding ring. What am I going to do with that? Do I trust my daughters to be able to come up with a solution there? Or do I need to come up with a process? Do I have art? Do I have an antique car? We had a client that had something that they sewed that's not worth a penny on eBay, but to the 3 children it was worth everything. And we had to develop a process for them to share it and exchange it every so often. So that was an interesting one, and I thank Attorney Chris Hervas in my office for that language. I did a good job drafting that. So that's the first thing you can do. Keep everything up to date. Be aware of significant changes in the law. But if you're using an attorney, even if you're not using an attorney, if you're using a computer program, go and try and keep track of, have there been changes? A lot of times, power of attorney's law changed, living will law changes, and of course the tax laws are constantly changing, and so it's very important. The second thing to do is if you are doing something controversial, if you are disinheriting somebody, okay, then make sure that, you've got a mental health check-in recently. If we have a client that we know is disinheriting one of their kids, we're going to do a few extra things. Number one, we want to make sure that we use good witnesses. Remember I said Florida doesn't have a disinterested witness rule? This would be a bad time to use the kids that are included as witnesses, because now they're not helpful at all. We want to find witnesses that are maybe lawyers or paralegals, or even better, doctors or mental health counselors. And we want to go through a questioning test. In other words, we talk about things. Who's the president of the United States? Who did the Dolphins win or lose this weekend? What's the weather like outside? What's your name? What's your address? Things that show capacity. And again, like I said just a moment ago, and let me finish, if you know you're intentionally disinheriting someone, there are extra steps you can take. Or if you likely that your documents are going to be challenged, make sure you get do it around the time of your annual physical. Get a letter from your doctor saying, hey, I've been this person's physician for the last 5 years. They just had a physical with me today, and I believe that they know the nature of their bounty and the extent of their wealth. It's a very low standard, but that's a great thing to do. Very difficult to fight that off. We do see some people that like to videotape their signings, or not my favorite. Because again, with editing nowadays and with body language, that can be, they were tapping their foot the whole time, so that must mean that they were nervous and somebody really had a gun that was pointing at them on the other side of the room that you can't see in the camera frame. And also, if you videotape and you don't always videotape, what made you videotape this one? So that's a difficult thing to prove in court. We've had more success with court reporters, which means we're getting everything written down. So and we can have that easily admissible to court. So we ask the person 20 minutes worth of questions before they sign their document showing that they had capacity. They could tell us their name, their address, who the president is, what the weather's like outside, what the local sports team did, or whatever their general interests are. Who are your kids? I have 3 kids. I hereby acknowledge that I am disinheriting one of them. Things that will help us much later on. So those are all things that we can do that make things easier. We can't stop people from bringing the litigation, but we can make it so it's going to be very difficult to bring that litigation. In addition, if you know that somebody's going to be likely to sue, then just doing a will is probably not your best effort. Again, it's better than nothing, but you might want to think about what options are available. You might want to do a trust. You might want to do an irrevocable trust. You might want to list beneficiaries on assets. You may want to make some gifts during your lifetime, especially of tangible personal property. It's a lot easier to say, Grandma gave me this ring, 2 years ago, than Grandma promised me this ring, so that's why it should come to me, even though there's nothing in writing. When they say possession is 9/10 of the law, they aren't lying. So that's something else to do. We also ask people sometimes to write a letter of explanation. We had a client who had a very, very wealthy child who worked in Hollywood, and they were leaving that person very little. And we said, do us a favor, write a letter just that we can put with this saying, he doesn't need any money. He was well off. He had more money than I did. And we actually asked them to give us a copy of the letter. Let us take a look at it in advance. Just an instruction. It's further evidence to show that what we're doing here now that this person is gone is truly what they wanted. It was done in the proper fashion. And most importantly, this person had the capacity to set this up and do it this way. If you think about it that way, from the attorney perspective, and I'm sitting across from a fellow attorney, our job is to poke holes in things. So we're always looking at what can we do to complete the circle. We're looking for places where is the weakness in the document. And when you go to Office Depot and you buy the package, it's a weaker document. If you go to an attorney, it should be a better document. I'm telling you, again, if that's what you want to do, great. I don't have any objection to it. It's better than nothing. But if you know you're doing something that's going to be controversial at some point in time, or you suspect it, then the more you can do now, it's going to make the life of the ones that survive you so much easier. And I think this is a good kind of place to end on the topic, which is estate planning is not for the person that does it. It's for the people that survive you. And our goal as estate planning attorneys is to make sure that your wishes are going to be carried out. And we have in our, in our tool bucket all of these options available. And the more information we have, the better we know what's going on, and the better job that we can hopefully do for our clients.
Amen. Oh, that was just a lot of information. Just quickly, we only have a few minutes left, but if anyone does have a quick question for Dr. Goldberg, we'll see what we can get to. You can pop it into the Q&A the webinar at the bottom.
I want to add one other thing that I forgot.
Please do. That'll give people time.
Make sure you shred and get rid of old documents. I can't tell you how many times we find 5 different versions of the will. Under Florida law, the one with the most recent date is the winner, but it gives people something to fight over. So if you're doing new documents, please shred your old documents, okay? Too much personal information to throw it in the trash.
Fantastic. Okay, so now I'm going to go to the Q&A and see if there's anything in there. And I believe I got one through.
Okay, and while you look at that, I'll give one other thought.
Please do.
Make sure that your loved ones know where to find the documents. Make sure you have a hurricane plan here in Florida, or tornado plan or fire plan, depending on what the natural disasters are in your neighborhood, that you can take these documents with you if you have to run relatively quickly. So that's something else that just a good practice point.
Okay, yes, we do have one question. Does a POD or being named on a document supersede a will?
Excellent question, and I'm actually going to give you an easy, unlawyer-like answer. Yes. Okay.
Wow, that's
it absolutely does. So TOD, just for the audience, stands for transfer on death. Some banks use ITF, which stands in trust for. Some banks and financial institutions use POD, which is payable on death. But that overrides. As long as that person is alive, it overrides. So you could have a will leaving everything to Miami Metro Zoo, but if all your accounts are POD, your next door neighbor, it's all going to your next door neighbor. So that's a great point. And it goes back to, if you know there's going to be a challenge and something difficult, that's something you can do to make the beneficiary's life a lot easier.
Oh, great answer. Thank you. Okay, one other person. Margaret has a father-in-law who died, and in his will he specified none of his 5 children getting anything, but they are still checking online in the Florida Treasurer.
Excellent.
If there is money in his name, who can claim the money?
Okay, so it's going to depend on, so there was apparently a will of some kind that said that the children get nothing. So the question is, who does it go to? We would look to that document. So we don't normally see wills that say you get nothing. It should say you get nothing, but you get something. So the question is what does that document say about who the something or who the somebody is that's getting it? Now, if it was a poorly drafted will and it says you guys get nothing, but then it's silent after that, now we have an argument that it goes under intestacy, which means you died without a will, which would in theory leave it to spouse if there is one, if not to the kids. And now, since the will was invalid, now we have litigation, because you can make the argument both ways. We have a document that's a will, but it didn't give us a list of beneficiaries, so Florida tells us who those beneficiaries are. Yeah, but I'm going to argue the other side now. But the document says not to these people. So the question comes is you would want to challenge that document saying this is a poor will, it wasn't done properly, and you can tell because it did the opposite. It said you don't get it, but never told us who would get it. So that's litigation. I'd love to have that case. That'd be fun to play with because that's going to settle. Because it's just, the judge is going to pick one side or the other, and somebody's going to be a really happy winner and somebody's going to be a really lousy loser. So that's the perfect type of case that would likely settle. But I would look to the document and see who is supposed to get it. And if you found money at floridatreasurehunt.org or whatever your state, Department of Finance is, New York one is really difficult to look at for my people in New York, by the way, but most states are easy. They're the people that should go and claim those funds, whoever was the personal representative of the estate. And if you didn't have an estate opened and the money's there, you're going to have to open an estate to get it, at least in Florida.
Fantastic. Well, that's a perfect segue because we had a number of people asking for your contact information, some attorneys on the line too for referrals and things like that. So do you want to, and we'll also maybe link it in the post follow-up, but do you want to just go ahead and give your...
I like to sit here with my professor hat on, so I'll just give a website.
Okay.
So if you're looking to reach us, it's rhglegal.com. We do have a blog there that you can take a look at, and you can also watch the video from last time on that website, and hopefully we'll be posting this again. But it's rhglegal.com, and from there you can find all our contact information.
Fantastic. It's a great firm. I highly recommend and exploring with other great attorneys, trust and estates attorneys around the country as well. So I think we are at the end of our hour, but I would like to mention to everybody in our legacy and gift planning department at Food for the Poor, we've created, with the help of some professionals, a trust and estates planning guide. And I like to recommend this. So if this is a resource that you're interested in, we're in the business of sharing information and resources to help you smoothly transition things and assets to the people and causes that you care about. We offer this. It's complimentary. It's about a 25-page guide. And if you're working with a trust and estates planning attorney, which I highly recommend, it will help you prepare for that meeting. It'll walk you through all your assets, some of which, as Dr. Goldberg mentioned today, you may have forgotten about, art on the wall, things of that nature. So it really helps you in that planning process. So feel free to reach out to us here at Food for the Poor in the Legacy and Gift Planning Department. That's what we're here for. I think they're going to flash my contact information on the screen in a little bit. So we are here for you. These are, whether it's Food for the Poor as a charity you care about, or another charity, or just smoothly transitioning to those loved ones in your life, that's what we're here for. So thank you so much for joining us. There we go. There's the contact information up. I'm sorry we didn't get a chance to answer all the questions, but I am going to look at them in the chat, and we are going to be doing this on a regular basis, so we will offer future sessions. I know somebody put in they're interested in trusts, elderly parent issues. There's so much to get into in this topic, so much good information. But I want to say a big thank you to Dr. Goldberg for sharing his time and talent with us. And many prayers to you and blessings to you for doing this. This is a donation of time, which I realize is an extensive donation.
Thank you for inviting me again.
All right. Well, thank all of you for joining us. God bless you, and we hope to see you again soon. If you're curious about Food for the Poor and you're interested in learning more about our work, please call or click. We're always here on a phone call away, and you could visit us at foodforthepoor.org. Have a great day.